curative jury instruction. Let me begin, Your Honor, by stating that there is a legally significant distinction between a confession and an admission in Massachusetts. And both are different in kind and character from state of mind or consciousness of guilt evidence. Prior to David Nelson's testimony, he's the tattoo artist, this court instructed the jury that it may consider the tattoos as state of mind evidence and for no other purpose. The Commonwealth ignored this instruction and in its closing argument characterized Mr. Hernandez's tattoos as confessions on 3 separate occasions. And in 2 additional occasions, the Commonwealth used phrases that are the functional equivalent of confessions. Mr. Baez, at the time, Your Honor, made a contemporaneous objection which the court overruled. Massachusetts law is clear on this point, and I quote, "The distinction between a confession and an admission, as applied in criminal law, is not a technical refinement, but it is based on the substantive differences of the character of the evidence deduced from each." Quote goes on, "A confession is a direct acknowledgement of guilt on the part of the accused." That's Commonwealth against Haywood, 247 Mass 6. An admission in a criminal case, in contrast, is, and I quote again, "a statement of the accused, direct or implied, of facts pertinent to the issue, which, although insufficient in itself to warrant a conviction, tends in connection with proof of other facts to establish guilt." End quote. That's Commonwealth against Lewin, Lewin, 407 Mass 269. So Mr. Hernandez's tattoos indisputably are not confessions. That is, they are not a, quote, direct acknowledgement on the part of, end quote, Mr. Hernandez. A direct acknowledgement would be a tattoo that read, quote, "I shot 2 guys at Pure nightclub, and then 7 months later I shot Bradley," end quote. That would be a confession. That would be a direct acknowledgement. We do not have a direct acknowledgement here. At best, the tattoos are an admission by a party opponent, allowing for, at most, an inference of culpability, quote, "in connection with other facts," end quote. Now, I will add that no case in the history of Massachusetts has used tattoos as an admission. That has been litigated already. Your Honor's written endorsement on our tattoo motion and Your Honor's instruction to the jury rightly did not recognize tattoos as a confession or as an admission. Rather,
well, actually, I did on the earliest motion, did I not?
That's not my memory of.
Well, that is my memory, that it could be viewed as an implied admission or as consciousness of guilt.
Well, if that's the case, Your Honor did not say it was a confession, and a confession is substantially and substantively different from an admission. So even if the court had previously ruled that it is an admission, a confession, according to Massachusetts case law, is distinctly and decidedly different from an admission. Now, Your Honor told the jury, notwithstanding what Your Honor wrote on the endorsement, that it may consider the fact that Mr. Hernandez got the tattoos as state of mind evidence, and I'm happy to play it for Your Honor if Your Honor desires. The statement, the instruction to the jury preceding Mr. Nelson's testimony was crystal clear. Mr. Hagan...
Well, it was a bad act or other act instruction, was it not? You may consider it for state of mind, you may consider it...
Your Honor said, first I remind you, Your Honor said, first, you may not consider the tattoo evidence as demonstrating anything about the defendant's propensity to commit crimes or to make use of guns or to be involved in gun violence. You may not consider this evidence as reflecting in any way on the defendant's character, that is, suggesting in any way that the defendant is a person of bad character. No evidence may be considered either to establish propensity to commit a crime or to show someone's bad character. Rather, this evidence is admitted and may be considered by you only insofar as you find It reflects the defendant's state of mind relating to the instant case. If you are not satisfied that the tattoo evidence you heard about is related to the events at issue in this case, and you may not consider such evidence for any purpose. On the other hand, if you conclude that the tattoos are based on the events underlying the case, then you may consider such evidence only insofar as it relates to the defendant's state of mind in determining whether the Commonwealth has proved this case beyond reasonable doubt.
Sounds pretty good. Now, are you objecting to... I don't believe there was an objection to the instruction at the time. Are you now belatedly objecting to that instruction?
We are objecting to Mr. Hayes' characterization, closing argument of that as a confession, which is substantively different from state of mind, which is substantively different from an admission, which is reversible error. And Mr. Baez objected contemporaneously. I'm happy to play Mr. Hagan's snippet where he used confession 3 times and the functional equivalent 2 additional times. Mr. Baez objected. Your Honor overruled the objection. That's what we are objecting to. And here's our proposition of law, Your Honor. This is consistent with Massachusetts cases and cases all over the country. And it is this: where an incriminating statement made by the defendant in a criminal proceeding is introduced into evidence, any description of such statement as a confession is reversible error if the statement does not amount to a direct acknowledgement of guilt. We submit that that is what happened here, that this tattoo
and I'm sorry.
As a confession.
Could I have the cite to that, please? What case?
They're all in my motion, Your Honor. This is a...
No, the quote you just gave me is from what case?
That's from Ronald Sullivan, Your Honor. That is everything in all the cases that I've said. Several say it's reversible error. I've summarized in my own words. The other 2 cases were direct quotes when I said in quote. We also submit that this error is a constitutional violation as it elevated the tattoos even beyond an admission and beyond state of mind or consciousness of guilt to a confession. As we argued previously, use of tattoos as an admission violated Mr. Hernandez's constitutional rights. A fortiori, the use as a confession does as well, and does even more so. Mr. Baez objected, and the court did not provide a curative. Finally, we submit that the Commonwealth's reference to the tattoos as a confession was egregious on its face, and the court, sua sponte, should have intervened and provided a curative. So the thrust, Your Honor, is that there are 3 different sorts of evidence: state of mind, consciousness of guilt on one level, admissions on another, confessions on a third. Massachusetts law has made clear, and there is no contrary authority in Massachusetts or any other state that a confession is the same as an admission, that they are different, used for different purposes. And several states across this country, and including the current state, has reversed convictions when a prosecutor has improperly claimed that a statement is indeed a confession. So we would ask, we would move for a mistrial on those bases. This, again, is the second time, perhaps the third, that the Commonwealth has disregarded the court's orders and instructions. In the alternative, we would ask that the court re-instruct the jury, advising them that this is not a confession or an admission, and give the instruction that Your Honor gave previously. Well, Your Honor already told them, or Your Honor did not tell them they could use it as an admission.
Yeah.
And I'm happy to play it. Your Honor told them state of mind evidence.
Are you suggesting that I should tell them that now?
I'm suggesting that you tell them that they cannot use it as a confession. That is constitutional error. That's a reversible error.
And why wasn't this request made during our charge conference?
Your Honor overruled the objection.
During the closing, but then we had a conference on the jury instructions.
I researched it this weekend, Your Honor. We made
it's a little late.
Well, we disagree. We made a contemporaneous objection. The case law says that we have to make an objection at the time when it happened. We did.
Yeah.
We spent the weekend researching this, Your Honor, and this is the law, and the law is clear. We submit that it's timely that Mr. Baez preserved the objection preserved our objection with his contemporaneous.
That preserves it for appeal. I'm not sure that preserves it for instructions. Let me hear what the Commonwealth wants to say to this.
Your Honor, Mr. Hagan's closing argument stayed within the bounds of proper argument in this case based on the facts. Your order dated January 9th, 2016 allowed the tattoo evidence to be viewed as an implied admission, admissible under Mass Guide to Evidence, Section 801 D2, subsection A. The rhetoric that was used in closing argument to take admission to confession is wholly proper. I would agree, based on the cases cited here, there is a legal difference between an admission and a confession, but I would guess that the cases my brother cites in terms of arguing a confession are based on facts of those cases. I need to look. I don't see the case that was cited for a legal basis to reverse. Again, I think the rhetoric is proper in closing argument to take the layperson's view that might not distinguish the admission from a confession, and it was wholly proper. And then, particularly in light of Your Honor's Your Honor's curative instructions generally to the jury, that closing arguments are not evidence; they're memories of the evidence control, and then thorough legal instructions. I don't think there's any basis for either a further instruction or for the defendant's request for a mistrial.
If I may, Your Honor, the case law says exactly the opposite of what Ms. Anderson says. In Haywood, the court is clear that this distinction between a confession and admission is, quote, not a technical refinement. The Commonwealth argued that it may be a legal distinction but have no practical meaning. The court said it is absolutely not a technical refinement. It's based on the substantive difference of the character of the evidence that's brought forth by each. So I would correct the Commonwealth on that claim and ask Your Honor for the remedy or remedies that we seek.
All right, I'm satisfied that a mistrial is not warranted on this ground. I gave the jury instructions at the time the evidence was admitted. I gave them comprehensive written instructions at the end of the case, and I informed them at the beginning of the trial itself. I informed them immediately before the beginning of closing arguments, and I informed them after closing arguments that statements by counsel are not evidence. They are advocacy statements. So I think the jury has not been misled, nor the defendant's rights offended. The motion, therefore, is denied.
I'm going to provide for the court our proposed jury instruction just for purposes of the record, and I will note that that was the single most powerful part of Mr. Hagan's closing, and it was improper to suggest that that was a confession. It was the single most significant moment of the day, and for Your Honor to conclude that stayed jury instruction somehow rebutted what is a clear improper argument absolutely befuddles this lawyer. But I understand the court's order.
All right. See if we can shake you out of your state of befuddlement on your next motion. A motion for a supplemental response to the jury question. Who wants to be heard on that?
The supplemental response, Your Honor, I do, to please the court. Here, this is with respect to Your Honor's answer to the jury's question yesterday. The court gave a bifurcated answer. The first was purported to be a direct answer of no, The second was a more detailed answer. Our central point here is this, that the court's oral direct answer of no presupposes one of two equally likely factual predicates. The specific testimony from an immunized witness referenced in the question could have meant one of two things. It's equally possible that the specific testimony from an immunized witness at issue in the jury question was the only testimony the jury credited as proof of an essential element of the crime. If that's the case, the direct answer should have been yes, you do need corroboration. If, on the other hand, the specific testimony is of another character, is of a different character, then your court's answer of no is correct. Given that it is, or the question is susceptible to two different renderings, we would ask for further instruction to clarify the issue for the juries.
Commonwealth?
Your Honor, it's up to the jury to ask for further clarification if they need to. I don't think that it's our providence now to bring them back in and instruct them, yes, if you meant this, no, if you meant that. It's up to the jury, and they can ask another question, and if they need further guidance from the court, they can do so.
All right. It seems to me that the instruction given on Friday directly answered the question the jury had put to the court. It was provided after consultation with counsel, and I think it accurately stated the law. I don't think that I ought to be reading into the question, the status of jury deliberations. And if the jurors want further guidance, they certainly can seek it by sending a note to the court. That motion, therefore, is denied. Now, counsel, while we're here, there is one issue that is worth addressing. It relates to claims made by the defense on Thursday before I instructed the jury. When Mr. Sullivan, you indicated an objection to the court's selection of a foreperson, first challenging or objecting to the timing of the selection. That is, that I selected a foreperson before drawing alternates, noting that I had told the jurors at the outset, preliminary instructions, that all would have an equal chance of being a deliberating or alternate juror. But then you went on to challenge the selection of the foreperson because the foreperson was one of two white women. And by selecting that individual, I was ensuring that at least one white woman would remain on this jury. And you indicated that because of the overwhelmingly ethnic and minority jury that was seated, my selection had extraordinarily troubling racial overtones that implicate the defendant's due process rights. I didn't address it at the time because it was important to get as much of the instructions done on Thursday afternoon as we could. And then on Friday, you folks were dealing with assembling the exhibits and completing the record check. But I do think it is appropriate to speak to this because accusing any court of being racist is not only offensive to the individual judge, but is extraordinarily offensive to the tribunal. and the integrity of the tribunal. It seems that your argument was, Mr. Sullivan, that because the foreperson that was selected was a white female, that person should not have been considered as a potential foreperson. Was that the claim you were making?
No. We find it offensive, frankly. We find it offensive that with this jury predominantly filled with people of color, that they cannot self-govern, they cannot self-regulate, that this court immunizes, in effect, one white juror and makes that juror the leader of this group. We find that offensive, Your Honor. I think it violates Mr. Hernandez.
Are you suggesting there shouldn't be a foreperson?
I'm not suggesting anything.
You just said that they would self-regulate.
I'm not suggesting anything. I am stating, Your Honor, that Your Honor should have done what Your Honor said he would do, and that is give each and every one of those jurors of color the same opportunity to stay on this jury as the white juror that we're discussing. That is my express statement. I'm not.
Well, no, that was your first. Your first statement was on the manner of selection or timing of selection. The second objection was on the selection itself, claiming that in some way the defendant was prejudiced because the court selected a white female. Now, I want to know whether or not, it seems to me implicit in that claim, is that a white female should have been excluded from consideration because of that person's either gender or race.
No,
was that the argument you were making?
No. My argument is this, that each of those jurors of color should have had the same opportunity
to be a foreperson?
To be a foreperson, to be on the jury as well. Both things. That is my express claim. Seems you can't.
Well, no,
tell the jury one thing and then do something totally
that's
different.
all right. I'm not focused on the manner of selection or the timing. I'm focused on your claim that the court, that there were, what was the language you used? Extraordinarily troubling racial overtones in the selection of one of two white women to be the foreperson, which suggests a claim that in some way this selection was improper based on race or gender. Is that the claim you are making?
Both. And they're inextricably bound, the manner and the substance of the selection, Your Honor.
As to the substance of the selection, you are suggesting that this court should not have chosen one of two white women because there were, as you said, an overwhelmingly minority and ethnic group of jurors on this panel.
No, I'll say it again, that Your Honor's choice of that foreperson is deeply troubling based on the ethnic and racial composition of this jury. I'm not suggesting anything. I'm stating very expressly that it is that...
Of course, there's a suggestion built into that statement.
I cannot control what Your Honor infers. I am making a direct statement. I'm not trying to suggest anything, no sub rosa comments. I am stating that it is deeply problematic that given the constitution of this jury, that this court, in violation of what it said it was going to do in the first place, immunized this particular individual.
No, I didn't immunize. I selected a foreperson. And the only objection that you can possibly voice now is that the person selected should not have been selected because that person was one of two white women, suggesting that this court should overlook, I suppose, the Equal Rights Amendment by excluding from consideration someone because of their gender or race. And frankly, I find that astounding,
we clearly
that
look
you
at it
would
through a
make
different
that
frame.
claim.
We look at it through a different frame. We think that the majority of the jurors who are of color did not have the same equal protection that Your Honor gave this single jury. So we look at it from a completely different frame. So both the manner and the substance we submit are objectionable on the grounds that I've stated. And to be clear, I'm not suggesting anything. I'm stating very clearly that this had very troubling racial overtones, and that each and every one of those minority jurors deserved the same chance that the foreperson got. And this court promised them, each and every juror, that they too would have equal protection under the law, that they too would have an equal chance of serving on the jury. You said that each and every one of you has an equal chance of being on the jury and has an equal chance of not being on the jury. So I can't decouple the procedure from the substance. That statement ended up not...
Well, no, you did...
I think it would fall... I'm sorry?
You did decouple them in your argument on Thursday. You decoupled them. You stated them as two separate grounds, one of which I'll live with, because I've always selected a foreperson before selecting alternates. It would be foolish to do otherwise. It would be foolish to take a well-qualified juror who'd given close and careful attention throughout the trial and who would be able to perform that function and then knock them off just by random draw. I don't know of any judge in the Commonwealth that would do that. But I'm not sure I understand your position, but at least I've explored it to the extent it can be explored and understood.
Well, it's on the record.
Yes.
Your Honor, and it is what it is at this point.
All right. Let us be in recess, and we'll wait to hear from our jurors.